is. I think the way I will do it is I'll take questions 3, and then the speakers can decide amongst themselves who will go forward with the answers to each individual question. But yeah, certainly plenty of time for questions on the floor. If anyone has a question, please raise your hand.
I suppose it's probably more directed at Wayne, but you talked about the processes of the court and them being cumbersome and a bit dysfunctional. I was just wondering if you advocated a sort of CPS-style approach to the prosecution, where they would get to decide on what cases to bring forward without the preliminary stage and the confirmation procedures as well.
Anyone else? Yes.
With regard to specifically when you were both talking about symbolic trials, do you see any, I guess, self-fulfilling prophecy problems in that if it goes, if a symbolic trial goes well, then it's perceived as a political, picked for political reasons, and if it goes poorly, then you've just undermined the symbolism of the ICC. How do you see symbolic trials, I guess, playing out in that situation?
Thank you very much.
I mean, we've heard of some of the constraints of the central ICC in The Hague, and also some of the benefits of a national level implementation. Is there any advantage of bringing in regional implementations as a sort of halfway house that kind of could reflect some of the regional issues and the sort of accusations of bias? Could there be some benefit there? So you have a global structure, but some regional deployment of better use of facilities.
Thank you very much.
Well, great questions actually. Well, let me deal with the first one, the CPS stuff. I mean, I think I have to say it's a long time since I've done an English case, so I'm sort of not so familiar with the CPS anymore. But if the question is sort of give the prosecution more discretion, then I would say currently no. Because I think that, although I think the confirmation stage and the different stages, for example, the preliminary stage where the prosecution has to be satisfied there's a particular standard, and then the full investigation stage where the pre-trial chamber has to decide whether there can be a full investigation, and a confirmation where they decide whether there's sufficient evidence to go to trial. I think these are valuable checks and balances on, the prosecution, but also checks and balances on whether a case goes forward. And I think a number of cases have failed at the confirmation stage, and rightly so. And I think that has saved the courts a significant amount of time and resources going forward with cases which were unlikely to be successful at trial. And I think there's a tendency in international prosecutions for international prosecutors to be overly optimistic about the strength of their evidence. And I think these checks and balances are important. I mean, the Bagbo, the problem is, I think, with these checks and balances is that they're not, the judicial decision making over them is sometimes quite flawed, as is the design. So, for example, the confirmation process, if, for example, in the Bagbo case, the prosecution went to the confirmation stage and they relied mainly on media reporting and hoped that that was going to get them through to a trial process, and the pre-trial chamber dismissed the case, but gave the prosecution an opportunity to go away and then come back again. So I think there's some value in looking again at the way in which the decisions are made in relation to these checks and balances, because I think if the confirmation stage, for example, was to the prosecution, get it right the first time, or you don't go again, I think that would have a really significant impact on the quality of the investigations and the quality of the prosecution work and the quality of the prosecution decision making. So I think that's more what's needed, I think.
And the second question was in relation to sort of the suggestion that the ICC has a role in conducting symbolic trials. Is there a risk of running symbolic trials that if you lose, you've undermined the goal you're trying to achieve, and if you win, it might be seen as sort of politicising the symbolic?
I suppose with symbolic trials, there's a risk of contributing to an imbalance in a particular country. So if you have one case in a country and it's on one side of a very fractious issue, it could create some kind of problem in terms of the perception. But on the other hand, if you were so equal, then you would have the other problem of well, this isn't a court, it's politics. So I think there has to be very clear criteria upon which to select cases. The prosecutor has worked on this quite a lot. I think it could be further enhanced, but I think applying it would be the first step. And then, in a way, you have less, you have more transparency in how decisions are taken about which cases to pursue. But then the justice itself, which follows in those limited number of cases, should not be symbolic. The justice which follows must be fully compliant with whatever standards are applicable in the system, or else you have a sham trial. It's not a symbolic trial, it's a sham trial. So I would say that. And then just on the issue of regional, I think it's really interesting. I think here one needs to be careful about having a regional structure, because some regions are simply either they're not part of the ICC, they're too limited. You don't have this parity amongst regions in terms of who's part of the ICC statute, so it wouldn't work as such. But you do have in the ICC the possibility for in situ trials and trials outside of the seat of the court. This they tried to, there was an application made that particular hearings should be in, actually both in DRC and in Uganda, and in both cases they didn't take place because of security concerns, which was very valid in light of those circumstances. But could they not have used the ICTR's courtroom in Arusha? Would that have been another alternative? Very possibly. And that, I think, would seek to engage the region in a more substantive way, in a very positive way. So I think there is room for that.
Thank you very much. Yeah, gentleman here.
You mentioned something about regional, the positive complementarity. So Bangladesh is currently running an international tribunal, which is fraught with a lot of controversy to do with due process. It also results in execution. So, how would you envisage positive complementarity in a context like that, where how does the ICC help in the due process issue as well as in the verdicts? It is left to the national legal system. Would there be conflicts of interest in terms of what the ICC supports and what the national government supports? Thank you.
Any other questions? No hands? Yes, yeah.
I'm not sure this is really a question, but I was going to ask whether it was an international law that the International Criminal Court could prosecute. But today, in the 1 o'clock news, it was announced that the UN, some section of the UN, had decided that David Cameron to start in August 2015 ordering the RAF to attack Raya Khan and other British citizens in Syria was not inappropriate. Now, I don't know about international law, but that's clearly in breach of habeas corpus in England. But doesn't the International Criminal Court take into account domestic law? Because twice that year, and the collection of evidence would be relatively simple. In March, before the election in 2015, Cameron made a statement to Parliament saying that he had ordered the RAF to attack 2 British citizens in Syria. Now, habeas corpus hasn't been repealed, so in English law that's a breach, but our courts, of course, are too weak. I'm surprised that prompted my question. Will the ICC not pursue domestic crimes as opposed to international. Well,
Thank you.
it's not very
I
nice.
can take one more question. Yeah, Claudia.
I'm going to be cheeky and ask two, if that's okay.
How about that?
For Carla, I wanted to ask, you highlighted a lot of the problems with victim participation, but what does better victim participation actually look like when you've got thousands of people in one case, for example? How would you have better participation, especially if they might not necessarily be witnesses and might be connected to how they're being victims? How would you really have them participating within a trial? And then for Wayne, what I wanted to ask was, you discussed a lot about extending the mandate, or you discussed a bit about extending the mandate in classic crimes, as it were. And also, maybe the ICC is moving towards having a structure which they'll have symbolic trials with more local, national implementation. I don't know exactly what your view was on extending the mandate, but what would you think of if they were extending the mandate to new areas that moved away from classic crimes? Could that not develop if you have symbolic trials that are then encouraging the encouraging prosecution on a national level? So I was just thinking, you mentioned about human trafficking or even environmental destruction. If you talk about land grabbing, there's a lot of things that aren't necessarily being addressed at the national level. I don't know, I didn't quite get what your view was on the extending of the mandate, or should the ICC retain its jurisdiction just on classic crimes?
Thank you very much. So I have to remind the first question in relation to positive complementarity and how that might give rise to conflicts with the domestic, when there are domestic investigations and domestic approaches, in the example of Bangladesh being cited. Second question then about effectively does the ICC have to take into account breaches of domestic law and kind of in what way take over there, and then obviously two questions from Champion. Whoever wants to take the lead on that.
Okay, I'll start with the gentleman's question. I mean, it's a good question, and Carla touched upon some of this, which is that the ICC doesn't see itself as a human rights court, and therefore, you know, in its founding discussions and built into the statute is this idea that its processes are not supposed to be a comment or condemnation of national processes, other than strictly within the complementarity framework, so willing and able genuine prosecutions and investigations. And you know, this situation came up in the Libyan case, and I was a part of the team representing Libya, and the defence were arguing that Gaddafi and al-Sanusi couldn't have a fair trial in Libya, and also that they would have an abusive trial which would lead to the death penalty, so it would be effectively a show trial which led to their execution. And the court took a very light approach to it, basically, and refused to be drawn into that commentary, other than to say they could envisage a situation where a trial was so flawed in terms of its human rights fair trial applications that it could amount to a lack of willingness to conduct a trial. But it was very, very, you know, pushed the issue away very, very carefully and forcefully. It is potentially a problem with positive complementarity because, you know, and this was happening during the Libyan proceedings where, you know, we were discussing with the prosecution whether, if they came to the conclusion that Libya wasn't able to conduct the trials, would the prosecution be willing to expend its resources to support the Libyan trials, because Libya had indicated that it was willing to go ahead with them. The prosecution didn't really respond to that because I think they, first of all, they had a lack of resources and didn't want to get engaged too much into positive complementarity. But what we found was that other institutions like ICT, Transitional Justice, civil society organisations like ICTJ, and the International Commission of Jurists were willing to be involved, notwithstanding the fact that the domestic trials, if they went ahead, weren't possibly going to lead to the execution. So I think, just to cut to the quick, I think positive complementarity is the way forward. I think the prosecution would have to be very careful in how deeply they were engaged, depending upon the national process. And if one can consider a situation where prosecution, expends huge amounts of resources to support a domestic trial, which leads very swiftly to an execution, it wouldn't look very good for the prosecution. But I don't think that's a reason for positive complementarity not to be encouraged and promoted. I think it's a reason for the ICC to be careful in how it does it.
On the other questions, will the ICC pursue domestic crimes? Quick answer, no. But the crimes that you mentioned could, in principle, depending on their scale, and in a way the scale could be big, potentially, could be a war crime, for instance, depending on the situation. They could fit within the crimes of the ICC, but then go back to the issue of, are they sufficiently grave from the perspective of the prosecutor's analysis of grave means many. So it's unlikely that the ICC would take up that kind of case. How could victim participation be better? I think there are examples that can be looked at to better engage victims in the process, both to ensure that the counsel who are standing in court are actually representing true interests, as opposed to more like a counsel, like a general interest without actually meeting the clients. They are clients, so there needs to be a process of engaging to seek instructions and to ensure that whatever happens in court is communicated back to the victims. So that requires quite a structure on the grounds, liaised with a smaller structure in The Hague. I think that would work better. I think you have, perhaps, in some cases, though, civil litigation lawyers might beg to differ how class actions work in practice, with some of the protocols which govern that area of work, whether that has a role in some of the procedural aspects of what would make sense to guide how victims should participate. The problem right now is that the court, you don't really have a lot of oversight of how the common legal representatives are operating. So the victims have very little recourse if they feel like they haven't been consulted. The only oversight of the common legal representatives, and obviously I'm simplifying, but it's really about their budget. So there's not really much for the victims to do if they feel like they're not being properly represented. So that's an issue. Also, I think better looking at some of the successful truth commissions could give some sort of one could possibly take some good aspects in terms of enabling victims to speak, finding ways in which to get some of that before the court through modern technology in a simplified way. There are things that haven't been tried due to lack of creativity.
On the Shanti's question, symbolic crimes and going outside the ICC prosecutors' previous sort of approach to the classical war crimes and crimes against humanity. I mean, I think there is. I'm with Carla in that I think from what I've seen from research, but of what I've seen anecdotally working in different countries, I think the the impact of the ICC prosecutor beginning a preliminary examination and that moving forward to a full investigation is significant. I think, you know, I'm working in Ukraine at the moment, and the preliminary examination is discussed at all levels of government. It's discussed among civil society. The ICC is, you know, it's an actor in the political and legal landscape. You know, in a surprising way, I think. And it's, of course, it's abused and it's misused and it's misunderstood, but it is really an integral part of the conversation. And I think, therefore, I think the ICC prosecutor should be taking a creative approach to crimes outside of her usual core crimes, because it has the potential to have such an impact at the national level, irrespective of whether it goes to trial, irrespective of whether convictions follow, providing those you know, preliminary examinations have begun and are evidence-led, that there is a basis for it, that there is a rationale behind it, that there is transparency and objectivity in the choices made, with a prospect of conviction, on, you know, a prospect of the court turning to it in due course and saying, we accept this falls within the ICC mandate. I think that this is really something the prosecutor should be doing. One of the cases which I think the prosecutor is going to open a preliminary examination into is or a full investigation into, I think, is the Cambodian land grabbing case, where the case advanced through victims is that the Hun Sen regime in Cambodia is a criminal organisation, effectively, which has instigated a policy of grabbing land from villagers and ordinary people and selling it to foreign interests. And the amount of people impacted are, you know, probably around 750,000 people have had their land stolen from them and displaced within Cambodia. And, you know, the argument is that it amounts to a crime against humanity, and it's an unusual case because crimes against humanity outside of a conflict, as far as I can think, have not been prosecuted at the international level. But there is no reason why it shouldn't be. 750,000 people displaced corresponds to the type of gravity that was prosecuted at the ICTY and has been prosecuted in the ICC. So, yes, outside the usual type of crimes, but and maybe just to finally, maybe symbolic is the wrong word, maybe expressive is the better word. You know, crimes which express the international community, whoever they may be, you know, repugnance in the conduct, irrespective of whether it's in an armed conflict, and irrespective of whether it's been prosecuted before.
Take another round of questions. If there are more questions,
I had a quick question in respect to the comment that you made, Carla, about the levels of political engagement from the ICC, and that I think you said that you thought it would be more effective as an organisation if it had a political angle, or if there were people working within the court who had access to those political channels. And I was just wondering if you could sort of expand on that and give a little detail as to what that political engagement on the part of the ICC would look like and how that would shape how it begins to operate in the future.
Thank you.
Hello. I was uncomfortable by the comment that perhaps Carla made regarding the ICC not going after certain cases because the person that they had identified was not high enough in the organisational chain. I'd like the panel's view on that, because I'd be happy with whichever perpetrator they caught, just to progress with it at whatever level.
Woman in red top at back.
Just a quick question about corporate accountability. Yes, corporate accountability within the ICC direction.
Corporate.
Yes.
Three questions. Political engagement. Comment, Carla, about need for perhaps a political animal in the SEC and expand on that.
It may be a wish list. It may be a wish rather than. It's a very difficult thing to say that the ICC should become more politically savvy. But if you think of the court as an institution, prosecutor has to be completely independent. But there's certain aspects, and the judges obviously need to be very careful about political engagement. But because of the cooperation mandate, if there was a very high level supreme diplomat running the cooperation side of the court, that would be very helpful. So engaging with the Assembly of States parties, encouraging the Assembly of States parties to take a stronger approach, having bilaterals with different states about an arrest warrant strategy. And the list goes on. There's so many issues which would need to be resolved. But it wouldn't be done by the judges, and it wouldn't be done by the prosecutor, I don't think. I would have doubts about whether the prosecutor would be appropriate in a full sense. Other questions? I don't know if you have a comment on that. Or
I think I agree with what you said, actually.
and in terms of high enough, I'm quite uncomfortable about what I said as well. It's simply my, I have a quote from the prosecutor in relation to, and I'm going to read it to you because it's exactly, if I can find it. This relates to her, it wasn't a decision, it was a view because it was in the media, so it was simply a statement by the prosecutor in relation to ISIS. So she said, the information gathered indicates that several thousand foreign fighters have joined the ranks of ISIS in the past months alone, including significant numbers of state party nationals from, and then she lists a whole range of countries. Some of these individuals may have been involved in the commission of crimes against humanity and war crimes. A few have publicized their heinous acts through social media. The information available to the office also indicates that ISIS is a military and political organization, primarily led by nationals of Iraq and Syria. Thus, at this stage, the prospects of my office investigating and prosecuting those most responsible within the leadership of ISIS appear limited. In the context, I've come to the conclusion that the jurisdictional basis for opening a preliminary examination into this situation is too narrow at this stage. But before I end there, remember what I said about victim participation and the inability of victims to engage at the earliest stages on what the prosecutor focuses on. That, in a way, is part of the problem with this, because you have almost no ability for the victims to put that issue before the judges and say, but hey, this needs to be dealt with. So that I see as a problem, which is very significant procedurally in relation to the discretion of the prosecutor, because the prosecutor has discretion as to what type of cases to pursue, but the discretion needs to be reasonable and transparently applied. So that's where you don't have much oversight, which is a challenge.
Accountability.
Yeah, corporate accountability. I mean, I would love to see it. I think one of the biggest problems, human rights problems we have, is the power of corporations and the amount of damage that they do, and the lack of legal regulation or legal enforcement against them. But it's not going to happen. I mean, because the ICC isn't what. It's not going to happen at the ICC. It may happen regionally. I mean, the new AU statute and their new court, which may or may not ever come into being, has corporate responsibility built into the statute. But you can imagine a situation where, let's say the Rome Statute was changed to allow the prosecution of companies, and the IC prosecutor chose Shell, which has billions of dollars to throw at the problem, and the ICC prosecution. This is why corporations are prosecuted are not prosecuted domestically in the US, and are increasingly not being prosecuted in the UK because it's easier to come to deals with them, and financially it's probably the only viable way to deal with many of these companies. So yes, it would be great, but I think it's a long way away, if ever. It was, of course, considered at the time of the Rome Statute and rejected, I suspect, for less principled reasons than the ones I've just outlined.
Thank you very much. I'm going to run the questions. Anyone have any more?
This question is to Wayne, and I appreciate that you may answer it in a bit of a nutshell. But I was just wondering, because you mentioned in one of your answers that you were involved in the investigations and examinations into Libya, what actually happened there? Because a couple of years ago there was a vast amount of reports and articles written on whether it was going to be successful or not, and where Saif Gaddafi and Al-Sanusi were being held in kind of tribal areas, and the kind of territorial fragmentation that was going to inhibit the ICC. And then it's just kind of reporting stopped, and I was fascinated in it, and I don't know where it's going, if it's going anywhere or hasn't going anywhere in the future.
Any more questions at the back? Yeah.
Another one about victim participation. I just wondered if you felt that there would be any more progress in terms of sort of two obstacles to meaningful victim participation. Firstly, victims being involved with the interview selection of which crimes have been prosecuted in the first place, get around the whole personal interests. And then also about applying. No, actually, just that one.
Any other questions? Take one more. Okay.
Both about the UK information into conduct in Iraq.
You haven't given us easy questions.
No. Libya, I can say very briefly. It ended up, as Carla mentioned, with the court essentially saying that it had jurisdiction over Gaddafi, and Gaddafi had to be tried at the ICC, but Al-Sanusi could be tried domestically. And then the ICC ordered the surrender of Gaddafi to the court. And then Libya ignored that. And well, actually, that's not fair. Actually, there's a contradiction in the pre-trial chambers approach, actually, because in relation to Gaddafi could be distinguished. I mean, I agree with Carla actually to a large extent that it was very difficult to distinguish the cases and why the court had taken a different approach. But the principal distinction, which was correct, I think, was that Gaddafi was held by the Zintan militia, and they were not surrendering him to the central government in what's the capital of Libya? Tripoli, sorry. I was a great lawyer for that. Yeah, they weren't surrendering him to Tripoli. Whereas Al-Sanusi was held in Tripoli, so the central government had control over him, and one of the aspects of the complementarity question is, do you have control over the accused or the suspect? So just as this was, I think the ICC prosecutor had reported this to the ICC, to the UN Security Council, and was moving, I think, closely to accusing the Libyan government of non-cooperation. She was very gentle in her approach, and I think she took the right approach. But just as she was moving to, I think, become a bit tougher on Libya, then Libya imploded. And so the news coming out of Libya is that the trials had begun of both Gaddafi and al-Sanusi. So on the face of it, Libya had ignored the order to surrender Gaddafi to the ICC. And to be honest, it's almost impossible to get any other news as to what's happening with those two.
I've tried.
I've tried too. Yeah, it's really there was this, as you know, the government collapsed and splintered into two, and it's a very, very complicated situation.
Wasn't there a mass trial in which the death penalty was imposed?
Actually, that's right. Yeah, there was a trial of both Gaddafi and al-Sanusi, and also lots of other high officials from the Gaddafi regime. Death penalty was imposed, but hasn't been. But I don't think it's moved to the appeal stage yet. But it may have done, but just the news hasn't come out. But yeah, that's right. The trial was completed, and the death penalty imposed on a range of them, including Gaddafi and al-Sanusi.
On that connection, the ICC hasn't considered prosecuting France, Germany, or Britain or the US for intervening in Libya. We attacked the country there.
Well, this is in some ways, though, also the misunderstanding in a way of the crime of aggression cannot be prosecuted at the ICC as yet. It may be enacted this year. It's subject to ratification by a number of states, and then in due course that may become something that can be prosecuted at the ICC. But the constant calls for Tony Blair to be prosecuted at the ICC are largely based on that misunderstanding, although it isn't to say that there isn't any case against him. One would have to look at what happened on the ground, but in terms of an aggressive war, that's not, it's not an option at the moment.
Just also to say on Libya that just recently, in the last few days, the prosecutor announced a new arrest warrant, which had been issued 4 years ago, but has just been made public. It also relates to Gaddafi-era crimes. I don't know the name of the person, but what's interesting is even though the Security Council referral is quite general and could relate to post-transition crimes, so crimes related to what's currently going on or what has been going on in recent years, the prosecutor to date has not engaged in those crimes to date.
She said she's watching them.
Yes.
She's made an announcement in a very stern voice.
I think the next question from them back was in relation to victim participation.
Yes, I think your question was on whether victim participation could be enhanced in the very early stages. There I would say there's been quite some success of victims working in collaboration with NGOs to draw awareness to the prosecutor in the first place of crimes taking place in any country. And if you look at the preliminary examinations currently before the court, a lot of those were started by NGOs working together with victims groups. So that's quite an interesting development. In terms of the scope of the investigation, once an examination has started, certainly the prosecutor is always open to receiving additional information. The prosecutor will seek information, but will also receive. So certainly, I would say there, the victims are yes, have a possibility to put information in. The problem tends to be that there's a lack of organization amongst victims in the very early stages, though this isn't always the case. So usually a combination with organization, like NGOs working together has worked well.